Welcome back to Central Colorado Ballistics. My name is Wally. Most people think modern gun laws come from modern politicians. They don't. They come from a law passed in 1934 and a Supreme Court case that never actually decided what people think it did. And we're still living with the consequences. Before 1934, the federal government didn't decide who could own a gun. It didn't issue permission. It didn't require registration. It didn't tax ownership. Instead, states regulated behavior, not possession. If someone misused a firearm, they were punished after the fact. But mere ownership wasn't treated as something the federal government needed to control. That distinction matters. Because regulating a use and regulating access are two very different things. And that difference is the fault line we're standing on today. So what changed in 1934? Fear, headlines, and a government that decided access was easier to control than behavior. The National Firearms Act didn't appear in a vacuum. The country was coming out of Prohibition. Gang violence dominated the headlines. Newspapers sensationalized crime. And politicians felt pressure to do something. But Congress knew something important. An outright ban on firearms would not survive constitutional scrutiny. So instead of banning ownership directly, lawmakers chose a workaround. They regulated the doorway. When the government can't ban a right outright, it makes exercising that right expensive, complicated, and risky. And that doorway became the National Firearms Act. The NFA did not ban firearms. What it did was regulate categories of firearms for the first time at the federal level. That included machine guns, short barrel rifles, short barrel shotguns, and suppressors. Ownership was still technically allowed. But it came with conditions. A $200 tax, which at the time equaled multiple years of wages. Mandatory federal registration. And discretionary approval by the government. The NFA didn't say, you can't own this. It said, you can if we allow it. That's not regulation of use. That's regulation of access. And the Second Amendment doesn't say shall not be infringed unless taxed. And then the Supreme Court got its first chance to weigh in, sort of. United States versus Miller, 1939. Two men were charged under the NFA for possessing a short-barreled shotgun. The case reached the Supreme Court. But here's what almost no one mentions. There was no defense attorney present. No evidence entered about militia utility. No factual record developed at all. The court did not rule broadly on firearm regulation. It ruled based on the absence of evidence in front of it. Miller did not say the Second Amendment allows regulation. It said the court had nothing to evaluate. And that silence became law. For the next 70 years, courts would treat that silence as permission. Over time, that gap hardened into doctrine. Lower courts leaned on Miller repeatedly. The Second Amendment was reframed as a collective right. And the Supreme Court stayed silent. The NFA survived challenge after challenge, not because it was clearly constitutional, but because no one forced the court to revisit it. The Second Amendment didn't lose. It was ignored. And ignored rights don't get defended. Precedent doesn't need to be right. It just needs to go unchallenged. That finally changed in 2008. In District of Columbia versus Heller, the Supreme Court finally affirmed what the text already said. The Second Amendment protects an individual right. 2 years later, in McDonald versus Chicago, that right incorporated against the states. But the victory came with a catch. The court allowed reasonable regulation. It protected long-standing laws. And the NFA survived. Not because it was re-examined, but because it was old. The court recognized an individual right, then preserved every law that had already existed. Including the NFA. That contradiction sat unresolved until Bruen. In 2022, New York State Rifle and Pistol Association versus Bruen changed the test. No more interest balancing. No more means-end scrutiny. Courts now had to look at text, history, tradition, and the burden shifted to the government. Here's the problem. In 1934 is not the founding era, and the NFA has no true historical analogs. Bruen didn't kill the NFA. It forced the government to finally explain it. And when the explanation gets shaky federally, states step in locally. Colorado doesn't need to enforce the NFA. It enforces the idea behind it. Feature bans instead of outright prohibitions. Registration schemes framed as safety. Taxes and fees presented as compliance. All justified through precedent. Once a right is regulated federally, states don't ask if they can regulate it. They ask how far. Colorado doesn't need a National Firearms Act. It already has the playbook. And precedent makes it defensible. One of the biggest misconceptions about the NFA is that it's frozen in time. It isn't. The framework still exists, even when parts of it change. We've seen moments where the cost of compliance is reduced, but the process remains. The ATF form remains. Federal registration remains. When the tax goes away, but the permission structure stays, you're not reducing regulation, you're normalizing it. And just as easily as costs can be lowered, they can be raised again. The lesson of the NFA is simple. If a right requires permission, permission can always get more expensive. The NFA was passed during a panic, upheld by silence, expanded by bureaucracy, preserved by precedent. So the real issue isn't machine guns. It isn't criminals. It's who decides and how long emergency laws are allowed to live. Temporary solutions have a habit of becoming permanent power. In the next episodes, we have choices. We can follow the federal trail and break down the next national gun law that built on 1934. Or we can stay in Colorado and examine how state-level restrictions mirror federal logic. Or we can go deeper into the agency that enforces all of this. How the ATF was created, why it was created, and whether an agency born out of prohibition still makes sense in today's Second Amendment landscape. Because laws don't enforce themselves. Freedom secured, rights defended.